I'm Susan Zesch. I have the great privilege of being a senior lecturer here at the university and executive director of the Human Rights Program. I would like to, before we start welcoming everybody and thanking our speaker and introducing our speaker, I would like to give a special mention to Sarah Moberg, who many of you know through her frequent emails to the human rights community in Chicago, and she is also the logistical chief of operations for us in the Human Rights Program and makes all the arrangements for these kinds of events. And that's the kind of work that's usually invisible, so I want to make it visible and thank Sarah. Sarah, why don't you stand up, because there are a lot of people here who get your emails and don't know you. She's back in the corner. I want to welcome two classes of students from the university. Mariela Schwartzberg's Human Rights in Latin America course students are here, and people from my course on Human Rights Contemporary Issues. And then we have people from a number of important human rights organizations in Chicago, the Kovler Center for Survivors of Torture. People are here, the People's Law Office, TAMS Year 10, who did a beautiful reception line for Juan when he came in, holding up signs saying, "Thank you, Juan Méndez, I am a mom." It's very nice. I think that many human rights advocates don't get thanked enough, and it's really nice that the TAMS folks and the TAMS moms came to thank him. We also have the Uptown People's Law Center is represented here, and Jean Snyder, who is a terrific prisoners' rights litigator. She's sort of an organization all by herself, considering the amount of work she's done. Mario Venegas from the Illinois Committee Against Torture, is that the right title? Yeah. Coalition Against Torture. And so anybody else I didn't recognize, we appreciate your presence and are very pleased to see an audience that is a mix of university and community activists, so welcome. Juan Méndez, I want to just bring people's attention to a program that will happen here in this room at the end of May, on May 31st, is our annual Robert Kirshner Memorial Human Rights Lecture. Robert Kirshner was a forensic pathologist who was one of the people who founded the Human Rights Program here at the University of Chicago. He investigated massacres, torture cases from Argentina, Palestine, Kenya, and worked closely with the lawyers on the John Burge cases here in the city of Chicago. Bob died a number of years ago, and we have an annual lecture in his memory. Juan Méndez was the speaker at that lecture about 3 years ago, I think. This year we're having a rather unusual presentation that's very closely tied to Dr. Kirshner's legacy. Margaret Ward, who is a professor emerita from Wellesley College, has written a book called Missing Mila. It's about the experience of her family. She and her husband adopted a son out of Honduras during the war in El Salvador. And when their son Nelson was, I think, in his early teens, they got a call from a project called Proyecto Pro Búsqueda, which was looking to connect babies adopted out of El Salvador during the war period with their biological families in El Salvador. And they had found Nelson DeWitt's original family. So Margaret Ward, who's the mom, has written a really terrific book which goes into a real understanding of the conditions of the war in El Salvador and the human rights problems and the reunification of this blended family across two countries. Her son, Nelson DeWitt, is making a film about the experience from his perspective. And so Professor Ward will talk about her book, and her son Nelson is going to show some excerpts from the documentary filming process. So we welcome you to all come back here, same room, on May 31st for the Kirshner lecture. And as all our events, it is free and open to the public, so bring your friends. Tonight we are very honored to have Juan Méndez here to speak with us. We really have in our presence someone who has lived the history of the development of the modern human rights movement since the 1970s. He started probably where no one wants to start, as a victim, being imprisoned and tortured in Argentina for his work as a lawyer. When he came to the United States in exile, he founded, among other organizations, America's Watch, which became part of Human Rights Watch. He has taught at Notre Dame University. He was the executive director or president of the International Center for Transitional Justice. When Argentina resumed being a democratic country, he was appointed by Argentina to be a commissioner on the Inter-American Commission for Human Rights. After leaving, he also established the Institute for Human Rights in San Jose, Costa Rica. And currently, after having also been Secretary General Kofi Annan's special representative for the prevention of genocide, his second United Nations appointment is that he is currently the special rapporteur on torture and other cruel, inhuman, and degrading treatment or punishment. He has had missions as the special rapporteur to several countries, including work in the United States that many of you are familiar with. And he is here tonight to present and tell us something about his career as seen through his book he's just published called Taking a Stand, The Evolution of Human Rights. He will be available to sign copies of the book, which the Seminary Co-op bookstore will be selling out in the hall after the lecture. So we invite you to get a copy of Juan's book if you would like. And we also want to acknowledge that iHouse has donated food for a reception for us afterwards. So there's trays of cheese and crackers at the back of the room for us to all have some time together after his talk. So without further ado, and I'm losing my voice, Juan Méndez.
Thank you very much, Susan, for that very generous introduction. I'm very happy to be here. I want to thank all of you for coming out. And I'm especially moved by this demonstration of support by the TAM movement here. If anything, I have only tried to contribute something from an international law perspective on why solitary confinement under most circumstances violates important principles of international law and obligations of the United States government vis-a-vis international law. It is that what my contribution is. It pales by comparison to the contribution that mothers and wives and relatives of people who are held in solitary confinement have been doing for years. If anything, I hope that we are seeing some light at the end of the tunnel because it seems to me at least that at least we're beginning to have a good discussion about solitary confinement in this country, and maybe part of that discussion can be part of our conversation tonight as well. Because I'm concentrating on the prevention and the punishment of the crime of torture, I will, talk more about that today. Although I hope in the question and answer period you'll feel free to talk about other topics of human rights as you see fit. But I want to start by stressing that the international community has now for a number of decades placed important emphasis on torture, on preventing it and on abolishing. In fact, there was a time when we thought that effective abolition of torture might be at hand. I think today we are a little more pessimistic about it. And I hope it's a momentary pessimism. But I think, eradication of torture has proven a lot more elusive and difficult than we had envisioned. And I think in the last 10 years, it has become more problematic to envision a day in which we will live in the whole world without torture, precisely because powerful nations have decided to, because of the global war on terror, to relax their opposition and their condemnation of torture, and that has had a very, very bad ripple effect in the rest of the world as well. And I think the worst aspect of that, quite frankly, and I think which is also the main obstacle we have in trying to obtain abolition and eradication of torture, is that unlike the years before the global war on terror, now we have to persuade public opinion about the evil of torture and the counterproductive nature of torture. Maybe because public opinion is influenced by fear of crime, or fear of organized crime, or fear of terrorism. Maybe because the culture, Hollywood and others, have kind of created this sense that not only we can live with torture, but it happens to others, it doesn't happen to us. It happens especially to people whose names we can't pronounce, whose faces we don't even want to see. And therefore, it seems to me that there is a certain acceptance of torture that wasn't there 10 years ago. And that's why I think that we have the tools of international law and of the international mechanisms that I'm going to describe to you in a few minutes. But I think the emphasis has to be on working at the culture, at the demonstrating the evil of torture and the counterproductive nature of torture by reference to the law, but also to specific instances and explanations, and particularly by giving a human face to the kind of pain and suffering that torture inflicts, so that we cannot escape understanding what we are standing for if we say that torture is in some way or another acceptable. But the first thing that international law does, and I have to say that as I started saying, the international community has paid a lot of attention to torture, obviously because the international community realizes that this is a very pervasive phenomenon, that it ebbs and flows, certainly, but it is a very easy way for states to exercise domination and power, especially if there are no safeguards and guarantees. And so at the heart of the evolution of the human rights movement and of international law of human rights is the struggle against torture. And it starts with a simple proposition. Torture is absolutely prohibited under any circumstances and cannot be justified even by reference to states of emergency or any catastrophic moment in the life of a country. The language is plain. It's absolutely prohibited. And the absolute prohibition extends not only to torture, but also to cruel, inhuman, and degrading treatment, which under international law is basically something less than torture. There's a difference of degree in the pain and suffering. When it crosses a certain threshold of pain and suffering, it becomes torture. Under that pain and suffering, but still with coercion and unwarranted physical or mental abuse, it's still prohibited. It's cruel, inhuman, and degrading treatment, and it's still prohibited. That's what was kind of lost, if you were following, in the so-called torture memos that during the Bush administration, two prominent lawyers at the Department of Justice wrote for the White House, because they accurately they said that the purpose was to decide whether somebody could be prosecuted or not for engaging in certain practices. And they basically said that the U.S. is obligated, not only by international law, but by domestic law as well, to investigate, prosecute, and punish torture. But anything other than torture, the United States is not obligated to prosecute. And so if you inflict cruel, inhuman, and degrading treatment, you may not be prosecuted. That's a very cynical position to take, because it kind of neglected to say that cruel, inhuman, and degrading treatment is also prohibited. So you should not be encouraging unlawful behavior in any event. But also, the memos are flawed because under any reasonable understanding of the level of pain and suffering that that torture requires, the techniques that are described in those memos qualify as torture, not as cruel, inhuman, and degrading treatment, but as torture, and especially if performed on the same person in conjunction one with each other and in the same time frame. So it's not only a disingenuous and wrong exposition of the law, domestic and international, it's also a very cynical exercise in encouraging bad behavior by United States agents. And of course, as you know, as I do too, the moment that those memos were revealed to the public, the White House actually withdrew them. So, relying on something that the White House itself decided that was flawed or wrong seems to me, a very bad precedent for the rest of the world. But I did allude to the fact that international law defines torture in certain ways and in a separate category condemns also cruel, inhuman, and degrading treatment. The definition, can be criticized on other grounds as well. For example, it's only state agents that can practice torture, and for the event to be torture, it has to have a specific intent, the specific intent of performing or inflicting the pain and suffering associated with torture. That specific intent is not included in cruel, inhuman, and degrading treatment, and that's why international law creates a mandate for the Special Rapporteur, me in this case, not only for the deliberate infliction of torture, but for all conditions in which, out of neglect, out of negligence, or simple, or for whatever other reasons, pain and suffering that amounts to cruel, inhuman, and degrading treatment is also prohibited by international law. And that's why we get involved in conditions of detention, for example, if they reach that kind of level. The definition also says that excluded are pain and suffering that is incidental to a lawfully or regularly imposed judicial penalty. And that has given us a little bit of trouble with the death penalty, for example, because under what conditions can we say, the death penalty is in and of itself either torture or cruel, inhuman, and degrading treatment? Well, what we have been doing, and not only the Special Rapporteurship, but other organs of international law like the Inter-American Commission on Human Rights, we have isolated aspects of capital punishment, and we have determined that they do become cruel, inhuman, and degrading treatment. For example, the death row phenomenon, and particularly, of course, if the death penalty is imposed without due process or without safeguards, that it will be imposed fairly. Incidentally, on that, the Special Rapporteur on Extrajudicial Executions and I are preparing a possibly joint or separate reports on the death penalty and under what conditions the death penalty violates either the prohibition on extrajudicial executions or the prohibition on torture. It's going to take some work, some research and some work, but we are committed to exploring this in a lot more depth and to try to get a good conversation going with the international community about the death penalty from these two angles. International law also provides for other legal effects that torture creates, other legal obligations and duties of the state. And the first and foremost, I think, is the obligation to investigate, prosecute, and punish each act of torture. And here, torture is unique in international law. because that obligation to investigate, prosecute, and punish exists for other crimes like disappearances, like war crimes, like executions, like massacres. But when they are committed as a part of a pattern of widespread or systematic violations, what we call crimes against humanity or war crimes. But torture participates of this ruling or obligation even when there's a single case. So torture is, for that reason, considered an international crime. And it's a crime that elicits not only the obligation of the territorial state, but also the possibility of other states contributing to breaking the cycle of impunity for torture by applying, for example, universal jurisdiction principles. So this is, as I said, an affirmative duty on the part of the state, and it's obviously a duty not only if it's it's obviously even more of a duty if it is part of a widespread or systematic pattern. And that's why it's very disappointing that the Obama administration has refused to look into the cases of torture that were probably caused by the memos that I alluded to before. President Obama, as you know, issued executive orders on his very first day in office, prohibiting torture and reestablishing the effectiveness of the Uniform Code of Military Justice that unmistakably prohibits torture. He also ordered the termination of the policy of extraordinary renditions and the use of black sites. For all we know, those things are not happening now. But one has to keep fingers crossed because unfortunately there's so much secrecy surrounding this that one can never be sure. My position, however, and I think it's shared mostly by international law jurists, is that that's not enough. It's very laudable, of course, and very good that President Obama did that. But President Obama also had the obligation to institute serious investigations, eventually leading to prosecutions where warranted and to punishment where warranted for every act of torture that was committed in the name of the global war on terror. Not only that hasn't happened, there hasn't been any further congressional investigations, even though before Obama's inauguration, there were some very laudable and very serious and very hard-hitting investigations conducted by Congress on several other aspects of the global war on terror. Another obligation, a third obligation, is the obligation to offer reparations and remedies to victims of torture. That includes not only the obligation to offer reparations, to try to establish, to compensate victims for the suffering, but also to offer rehabilitation services where needed. But it also includes what we call remedies, meaning the establishment of procedures and safeguards by which a victim of torture, and even a prospective or potential victim of torture, can mobilize institutions to prevent torture from happening. Obviously, I'm referring to the writ of habeas corpus, but there are many other safeguards that can and should be instituted. In the United States, those safeguards generally are there. Whether they actually work adequately or not is a different question. But you can imagine that in many countries of the world, those safeguards are not there, and it's very important for us to insist on them, to insist that they're not expensive, that they're not out of reach for poor countries, but also that there are examples in the world where these mechanisms do work. And unfortunately, when they are made not to work by powerful governments, then the bad example is easier to be imitated than the good example. In the question of remedies, I'm also disappointed that the U.S. government has successfully objected to the civil lawsuits against enterprises and people who may have participated, may have been complicit in torture. A case called Jefferson versus Data Plan, which, as you remember, is a case brought by the ACLU and others against a company that transported victims of torture to black sites and to extraordinary renditions. The government exercised and succeeded in preventing the case by invoking state secrets. It seems to me that state secrets are an important weapon in the arsenal of any state, and that there are secrets that have to be kept. But I would, at the very least, offer the proposition that there can be no secret to hide human rights violations. In fact, President Dilma Rousseff of Brazil last December, in creating a truth commission for the crimes committed by the military dictatorship decades ago in Brazil, finally creating that truth commission that Brazilians have been expecting for so long, they had to amend also their confidentiality and state secrets law so that that truth commission can really delve into some documentation and testimony in order to get to the bottom of things. And she said, there are no state secrets when to protect human rights violations. And I think that's a very good proposition, one from where we should have a good starting point. Beyond that, I also think that the offer of reparations and remedies should cover any and all participants in the crime of torture. And unfortunately, the Supreme Court has just issued a decision in a case called Muhammad versus Palestinian Authority, in which it said that under the Torture Victim Protection Act, the civil sanctions or civil lawsuits do not lie against non-physical persons. There's a separate case called Koibel versus Royal Dutch Shell, in which the issue is not just another entity, but a business corporation, as at least allegedly having participated or being complicit in the infliction of torture. That case has not been resolved yet, but it seems that there's very little appetite for opening the courthouse doors to claims against corporations. So it's interesting that corporations seem to have rights, especially First Amendment rights, but they don't have accountability for what they do. But I think the struggle has to go on that and other things as well. I think another important legal effect is the exclusionary rule. You know, obviously that terminology is a United States constitutional theory, but in similar terms, not exactly in the same terms, it applies in international law as well. Because the Convention Against Torture says that states are obliged to prevent the use of confessions or of any kind of declaration obtained under coercion from being used in a judicial process, except when torture is being investigated and for the purpose of showing that a statement was made as a result of torture. Unfortunately, the exclusionary rule in international law is more limited than in US constitutional law. In my position as Special Rapporteur, try to persuade governments to go beyond the strict limits of the Convention Against Torture, and with an outlook to actually prevent torture from happening, go more towards something like the fruit of the poisonous tree doctrine. That is, not only confessions and declarations obtained under torture should be excluded, but everything coming out of that, that has led the investigators into some evidence if it originates in an act of coercion. That's not, I have to stress, not part of international law today, but I think it's a proper way of understanding the prohibition, especially having in mind what the objective of the prohibition is. The other problem with that norm in international law is that the Convention Against Torture says declarations and confessions known to have been obtained under torture, which in many countries ends up putting the burden of persuasion on the victim. And you and I know how easy it is for the police just to wait 5 days so that there's no evidence of torture. And so when you go and say, yes, I said those things, but I was tortured, the judge will tell you, well, prove it. And if you can't prove it, then the statement is admissible. Unfortunately, that's the way this rule operates in most parts of the world that I have been aware of. And that's why we need to stress the need to have a more teleological, if you will, understanding of what the exclusionary rule is all about. And then a final legal effect is the prohibition of what's called refoulement, meaning sending somebody to a country where he or she could be the victim of torture. Now, that is a principle that comes from the 1951 Convention on the Status of Refugees. But in the case of torture, it's much more absolute, because non-refoulement for refugees, obviously it's not only for torture, but for many other types of violations, does not apply for someone who has been himself a persecutor of others. But the prohibition in the Convention Against Torture applies even for people who themselves have committed very serious crimes. If they're going to be tortured, you simply, a state simply cannot extradite or deport someone to that country. Now, all of this is an arsenal that helps us fight torture, and yet torture is practiced in at least half of the countries of the world at any time today, maybe even more. And if you include cruel and inhuman and degrading treatment under the definitions that I already mentioned, then the number of countries that practice it is probably 193. That is, all countries in the international community. So that's all the more reason to have mechanisms and instances by which we arm ourselves to fight torture and cruel, inhuman, and degrading treatment. And those at the universal level, that is at the United Nations sponsored level, include the Convention Against Torture and the Committee Against Torture that it creates. It's a treaty body that deals with that convention. And that committee does its work by, taking on individual cases, but unfortunately only for those countries that have made an additional declaration that they accept the jurisdiction of that committee. And there are very few, unfortunately. And the United States is a party to that convention, but has not made that declaration. So individual cases cannot be brought against the United States. Second, by issuing commentaries, which are elaborations on what should be understood by the norm in each article of the convention that tend to have a lot of authoritative value. And the third is the periodic country reports. State parties to the convention have to come before the committee every 4 or 5 years, I believe it is, and the committee issues a report. There's a self-report and a response report by the committee, and that is a very good opportunity to highlight and bring out all the issues of torture in that country. The Human Rights Committee, which is the treaty organ of the International Covenant on Civil and Political Rights, it's a much broader instrument, also has done some excellent work on torture, because torture is also prohibited not only by the Convention Against Torture, but by the Covenant on Civil and Political Rights. Then there is an optional protocol to the Convention Against Torture that is meant to do prevention. And it creates a committee, a subcommittee actually, of experts whose methodology is basically preventing torture by visiting places of detention. And over the years, they have developed quite a methodology for visiting places of detention, both periodically but also unannounced, and for insisting on terms like being able to visit every part of every detention center, including not only prisons, but all places where people are deprived of freedom, including, for example, mental health hospitals. They issue confidential reports to the states, but invite the states to publicize those reports. And they do, I think it's an effective mechanism. It's copied actually from a European institution called the Committee on the Prevention of Torture also, that has done some excellent work over the years as well. And then there's a charter-based, non-treaty-based mechanisms, including the special rapporteurship that I presently occupy. The special rapporteurship on torture is one of many rapporteurships and working groups that deal with different themes and sometimes with different countries as well. The special rapporteurship on torture is one of the oldest ones. It was created in 1985, and before me, 4 very prominent European jurists have occupied it, and they have created a very high platform of expectation on the quality of the work. But they've also demonstrated the worth of the rapporteurship because it's one of the most visited, one of the most demanded of all the special rapporteurships and working groups at the United Nations. Basically, we do our work in 3 ways. One is individual cases. But those individual cases, the good thing is we have jurisdiction over 193 countries because we are not limited by the Convention Against Torture. The downside of that is that it's very clear that whatever we say is not binding on the state. So we are basically meant to do recommendations. We also receive these complaints from the public, but we are bound to treat them in a confidential manner by writing a note to the government and asking for information about it. For all that initial period, the procedure is confidential. But at the end of the process, I'm not obliged to, but I do, issue my views or my commentary or my judgment, if you will, over whether a violation of the Convention Against Torture has occurred or not, and why, and to make recommendations. Last month in Geneva, I presented my report to the Human Rights Council, and I included an annex with 250 decisions of this sort of cases that we worked on over the previous year. It's not a very effective way of doing things for the reasons that I already mentioned, but it must do some good because there's a lot of people demanding that we do it. And I think, in fact, it helps to raise awareness, at least, of an individual problem. The second way we do our work is by our semi-annual reports, one to the General Assembly and one to the Human Rights Council, in which we choose to develop a theme related to torture, in my case, that should be the subject of discussions among the international community, and we try to generate a discussion. We are free to choose the subject any way we want. As I said, the next one will probably be about capital punishment. The previous 2 that I've done are one about solitary confinement that I presented to the General Assembly last October, and the one in March was about commissions of inquiry about patterns of torture. In each case, it seemed to me that the criteria that I used to decide on the topic was, one, whether there was an extended practice, and it seems to me from everything I was hearing, solitary confinement was growing. It had been used in many different countries for many different purposes with very little safeguards and increasingly for longer and longer periods. And so, and at the same time, I felt that international law didn't give us a whole lot of guidance as to, under what circumstances solitary confinement may or may not be justified. So I very deliberately wanted to set forth some ideas for setting those guidelines and coming up with agreements as to that. About commissions of inquiry, the main problem there was that some governments were using commissions of inquiry as a way of circumventing the obligation to institute criminal procedures. And so we wanted to make sure that commissions of inquiry are an important tool if they go in the direction of serving the purpose of fulfilling the obligation of the state to investigate, prosecute, and punish. That they shouldn't themselves be a prosecutorial instance necessarily, but they should open the way and lead the way to prosecutions, not be an alternative to prosecutions. And also there are examples, especially in the area of transitional justice and truth commissions and truth and reconciliation commissions, that give us some guidance as to under what conditions a commission of inquiry does its work well. For example, transparency, victim participation, not only victims being heard, but victims being heard in the design of the process itself and in the execution as well. And also the relationship with state secrets is important. If a commission of inquiry is going to be hampered by the executive branch coming in and saying, you can't touch this, you can't reveal this document, then that commission of inquiry is likely to fail. And the third way we do our work is fact-finding missions. And there, I've been to Kyrgyzstan and to Tunisia, and I'm going next month to Tajikistan, and in September to Morocco and Western Sahara. In the meantime, 2 missions were aborted at the last minute because governments did not fulfill their promise to let me in. One was Bahrain and the other one was Iraq. Obviously, they said they wanted to reschedule, and we're working on rescheduling, but I'm not holding my breath. And I'm going to Uruguay on a follow-up visit because my predecessor was there in 2009, and the government and civil society, I should say, are willing to show what they did in response to recommendations made by Manfred Novak. So I think follow-up missions are very important as well. We are only now beginning to think about how do we do follow-up. But I have to say that all of us, the United Nations and even in the regional organizations, are particularly concerned with the issue of compliance. Why do we do all of this if the states then decide whether to take it or leave it? So insisting on follow-up and insisting on compliance should be a more integral part of what we do. With respect to country visits, I have to say that I've been negotiating with the United States to go to Guantanamo. After a year, the Pentagon offered me an invitation, but it was in the same terms in which my predecessor, Manfred Novak, was invited in 2004, and the terms that we cannot accept because they don't include any visit, not even monitored visits with inmates. And so to get a guided tour of Guantanamo, unfortunately, I'd love to go anyway, but the rules that the Human Rights Council has imposed on me do not allow me. Nevertheless, I am considering the possibility of going to Guantanamo as part of the negotiation process until I get a serious invitation. But even that is unclear because we don't want to set a bad precedent. You can imagine that if I accept a visit under those terms, it's going to be difficult to convince Morocco to let me to visit prisons in Western Sahara and to have unmonitored private conversations with inmates. But with regards to the United States, I've also formally asked for an invitation to go to ADX in Colorado, and to look at immigration detention centers, especially those that are using solitary confinement for immigration purposes. It's a case that we've been working on, and we want to see some of that. I'm probably going to have to do a country visit to the United States in stages, because this is such an enormous country, and of course, it's difficult to decide on which places to go. But I definitely want to visit state prisons as well, and that in the federal system takes a little more negotiation. So maybe I'm going to start with federal facilities and then move on to some state facilities as well. And I think for reasons of practicality, I should mostly concentrate on maximum security facilities, although obviously my mandate extends well beyond that. I have gone on too long, but I hope I've laid out a few questions that can be discussed. Especially, I'd be very eager to have your thoughts on the two thematic reports that I've already published, because, as I said, they were meant to generate a discussion, and they may contain some error as well. So I have to say that when I started this job a year and a half ago, I said that since I was the first torture victim to occupy this position, my approach to the mandate was going to be victim-centered. And then I had to clarify that I didn't mean to say that my predecessors did not have a regard for the victims. On the contrary, they have been very, very sensitive to them. But I think, without major changes in the way they did their work, it seems to me like it's very important for me to first and foremost look at pain and suffering from the perspective of the person that suffers pain and suffering. And particularly, as I said at the beginning, because I think our publics get used to the idea of torture and get comfortable, quote unquote, with torture because they refuse to see what it does. And so if we can highlight what it does, if we can highlight the suffering, not only that the victims, the direct victims experiment, but also their relatives, their loved ones, etc. And what it does to the torturer, to the person who inflicts, and the institutions for which they work, I think we have a better chance of envisioning a time, maybe in our lifetimes, in which we can say torture has been abolished. Thank you very much. Should I recognize myself? Or? Okay. Then we need to, for anybody who wants to participate, to come to the mic.
Thank you, Mr. Méndez, for coming out tonight. I have a son that's in TAMS Correctional, and I would hope that you would put TAMS on your list of places to visit, because it is a place of torture. I have a son that's been there for 12 years, and in those, it was meant only for short term because of the effect on the human mind, and he started cutting himself, and the effect on the mind is horrific. And I'm here in behalf of all the families of TAMS asking you to help us. And I just want to thank you for coming out, and thank you for caring.
Thank you. Thank you. I have received some complaints about TAMS, and I'm working on them, but I have not issued any report on it. I guess I need more specific details about cases, but I'm very willing do that. Interestingly, from what you said, I mean, some of the rationales, if you want to call them that prison authorities give for administrative measures, they're not even disciplinary, because if they impose disciplinary measures and isolate somebody or segregate somebody for disciplinary reasons, then they have to give them a hearing. But they call it prison management, and they basically say, well, this is a person that hurts himself. But it seems to me that it's like a chicken and an egg situation. These persons hurt themselves because they are there, not the other way around. Yes. And they seem to be oblivious to, you know, to what the consequences are of segregation and isolation. In my report, I actually called, again, as a sort of throwing ideas for discussion, but I called for an absolute ban on the use of solitary confinement for minors, for people who have any kind of mental problems, and in an indefinite fashion. Because it seems to me like the indefinite nature of solitary confinement just adds to the uncertainty and anxiety that is consistent with mental pain and suffering prohibited by international law. But I also called for a ban on prolonged arbitrary detention. And using some of the medical and psychiatric literature, I said, you know, kind of arbitrarily, 15 days should be the maximum. And that's because I recognize that in some cases solitary confinement may be necessary. But even for those cases under 15 days and where it's necessary, I also called in my report for a variety of medical and legal safeguards against abuse. I'm sorry to go on around this, but you have another question?
Yes. Well, I just wanted to say to everybody here, if you would contact your legislators and please tell them to vote to close TAMS, because these people are locked up 24 hours a day. They have no programs, no educational programs. They're treated worse than animals. They're just locked up in what we call a gray box. They sleep on cement beds, it's terrible. And it's something that everybody here should be concerned with. And I ask all of you to contact your legislators and tell them to cut off the funding to TAMS and to vote yes for closing TAMS.
Hi, Mr. Méndez. I applaud the work that you do. I'm Anthony. I'm a former staff member at the university. I'm somewhere else now. And I applaud the work that you do. I especially applaud the very thorough report that you did on Bradley Manning, exposing America's cruel and inhumane treatment of Bradley Manning. I really appreciate you providing that report and detailing what you did for that. Do you have a response to the National Defense Authorization Act, which allows the American president to kill American citizens without due process, without any transparency, or having to provide any evidence of the person that he's being allowed to kill? Do you consider that torture or war crime?
Well, I should start by saying that my mandate extends to mistreatment, not to extrajudicial execution. For that, I have to respect the boundaries of the mandate of my good friend Christoph Heinz from South Africa, who is the Special Rapporteur on extrajudicial executions. But maybe I can answer in my capacity as a human being and not as a Special Rapporteur on torture, and also as a professor of law. And I have to say, targeted killing of an enemy combatant in the theater of war is certainly not prohibited by international law. But it seems to me that extending the whole idea of war to all kinds of other situations is a very dangerous, very risky proposition. And I think the administration has not explained the contours of the policy, because, as I said again, first we have to, take the word for it that these are enemy combatants. Second, we have to take the word for it that they have good information not obtained under illicit techniques, which they don't reveal. They don't say how they select or why they select. Again, state secrets, predominate. And third, they actually apply it to people who they feel have made a contribution to the war effort of Al-Qaeda and other, so it's like open-ended. When Al-Qaeda disappears, and it will disappear one day, there'll be all other kinds of terrorist organizations because, terrorism, unfortunately, is not going to go away. And frankly, if anything, it's going to grow because of these, badly planned ways of fighting terrorism. So if you're targeting people who, under all other circumstances, would be considered a target at most of a law enforcement process, then of course it's a targeted assassination. It's what it is.
Thanks very much for your speech. I just have a question a little bit about, I'm Steven Laurie. I'm a third-year undergraduate here, and I guess study human rights a little bit. And I had a question about, you use the phrase in terms of working on culture or working to change the international culture that surrounds torture as a key preventative measure. And I was just wondering how you envision this change occurring, particularly who are the actors that can help to change the culture that surrounds torture, the discussions, the discourses that go on pertaining to it. Does this mean that international organizations such as the UN have to act? Does it mean that individual states ought to change the culture inside their own country? Does this mean that NGOs ought to hold the burden? I wondered if you could just elaborate on that.
Right. I was afraid that you would ask me how. Well, I think all of that. I think the international community does, can contribute some very formidable, kind of putting the spotlight on countries that torture. But even that is not enough if the domestic forces, and particularly domestic forces in a democracy, don't give the importance that the issue of torture deserves, and therefore, are busy with other things that are obviously equally important as well. So yes, I was thinking mostly about civil society, about the organized part of civil society that specifically deals with human rights, NGOs, but also the media, and particularly engaging the debate, and not shying away from questions of, for example, effectiveness of torture. It's been difficult, especially in the United States, and I would say in Israel also, to say, things don't work. And I think it's particularly difficult to say that all the information that you get out of torture is, by definition, wrong. It isn't. Unfortunately, some of the information is misleading. A lot of it is real, but I think we can argue that states pay a very heavy price for allowing their institutions to engage in torture. And I know because my country was one in which, with the community, so to speak, looking the other way, and certainly, cowed under by fear, but with the refrain of, well, they must have done something. Algo habrán hecho, we used to say in Spanish. Then we tolerated torture. And then we found ourselves with police that we cannot trust, a military that the population despises, very difficult to rebuild prosecutorial offices and judicial offices, etc. And 28 years after the return of, almost 30 years after the return of democracy, we're still struggling with those things.
Thank you.
Thank you.
My name is Mario Venegas. I am a survivor of torture from the Pinochet regime in Chile. I am activist here in human rights in a number of institutions in the Chicago area. work for Illinois Coalition Against Torture, Illinois School of the Americas Watch, Amnesty International, and also a client of the Kovler Center for Survivors of Torture, for the treatment of survivors of torture.
Thank you for coming.
And thanks for you being here with us and sharing your thoughts. But when you just started your talk, you mentioned something that I would like to clarify or kind of disagree.
Okay.
Because you mentioned that there is a certain acceptance today of torture all over the world that's not before. And at the same time, you said that there's an envision of a day without torture that you are very pessimistic. And I think that particularly here in the United States, we have worked extensively in this campaign against torture, making consciousness of the people of the United States about what this terrible human rights violation means. And at the same time, locally, Illinois Coalition Against Torture, together with any other organizations, the ones I mentioned already, were able to present at the City Council of Chicago a resolution of the City Council to declare the city a city free of torture. Legally, probably doesn't mean nothing, but symbolically, politically, it's so important for us survivors, for the people that have been tortured in the city of Chicago by John Birch, the commander of the police department, and also for the people that are still in detention because of the reason of torture by Commander Birch and his people. So that's why I don't totally agree that we are so pessimistic. I think you faced your talk mainly about the challenges and the difficulties, but all the advance and the progress that we have had in the campaign against torture, I think it should be told everywhere you are present in terms of what different countries are doing and what even cities like Chicago we have been doing.
Right. Well, thank you for the question. It really gives me an opportunity to clarify, because I didn't mean by any means to say that any of the many very brave organizations, not only in the United States and in Chicago, but around the world, have given up or have, been ineffective. On the contrary, I think they are very inspirational, and they show the way to effectively defeat torture in the near future. I also, I don't think I said I was very pessimistic. I said that I was, in comparative terms, more guarded about dreaming of a day in which torture would be abolished than I was before 9/11. And the reason for that is that before 9/11, I was working mostly with Human Rights Watch and other organizations, and it seemed to me like we didn't need to explain a whole lot why torture is evil, why torture should be condemned. Governments, especially democratic governments, readily admit it, and they, in fact, praise themselves of never using torture. We didn't have a Harvard law professor arguing that we should have torture warrants issued by judges. We didn't have this sometimes silly discussion about the ticking bomb scenario, which at least you and I know, in the Southern Cone, we heard those arguments back then, and we thought that we had buried them, and they've resurfaced. It's that kind of battle for the hearts and minds of society that I was referring to. And I also feel that it is a momentary lapse. It's not something permanent. That's why I'm pessimistic, but I'm not very pessimistic. Thank you.
That's good. Thank you.
I'm Paola Castaño. I'm currently writing my dissertation here in the Department of Sociology, and I'm writing about the Colombian Commission of Reparation and Reconciliation. Mm-hmm. And I wanted to ask you about that because this is my puzzle, I guess, in my dissertation, and I wanted to ask you your thoughts on kind of the proliferation of these transitional justice mechanisms, even in context in which, of course, there's not a transition as such as it is the case, as it is the particularity of the Colombian case. But I guess overall, I'm curious to see what is the threshold between the usefulness of this, as you mentioned, the Brazilian case that is relatively recent, the usefulness and the banalization of these mechanisms, and the invocation of the transitional justice as this promise to fulfill human rights, the achievement, I guess, of human rights, and all these different struggles that have taken place particularly in South America with regard to these issues.
Yeah.
And how transitional justice offers a platform and these commissions an institutional form, but also what does that proliferation entail? I'm interested in your thoughts on that.
Yeah, well, I in fact think that transitional justice mechanisms offer a way out of some of the challenges that we have, even exclusively on the area of torture, although, as you know, transitional justice refers to the way in which societies deal with legacies of very serious abuse and massive and widespread abuses, and of different sorts, not only torture, but disappearances, massacres, extrajudicial executions, etc. But I also feel that it's very important to be clear about what we mean by transitional justice and for what purpose. I think the peace and justice law, justice and peace law in Colombia is an example of where the line is not drawn clearly, because in my mind at least, President Uribe promoted this law that has 20 pages of wonderful language on justice and peace, only to betray those principles at the very end in basically 2 or 3 norms that belie the obligation to investigate, prosecute, and punish these crimes, and creates a system by which they're not exactly amnestied, but the mechanism is so complex and so difficult that it is a combination of de facto and de jure impunity. Now, I also want to stress that the Constitutional Court of Colombia amended that law in some very key factors, and so the law could have been, if implemented in good faith, could have been a good instrument for transitional justice, even with some concerns that we might have about the proportionality between the penalty that paramilitaries would obtain and the gravity of their crimes. But in fact, in practice, nothing of that has happened, because of the extradition to the United States of the major criminals. There hasn't been any prosecution, any serious prosecution, any conviction of anybody under the Justice and Peace Law. But I know that you asked about something that's related to that, that is the law of victims, as I think they call it, and that has to do with reparations and the commission.
Precisely when transitional justice sort of becomes a permanent form of governance, which I think it's also.
Right. Yeah, well, I hadn't thought of it in those terms, and I think you're absolutely right that transitional justice should not be seen as a substitute for the regular functioning of justice. But I also feel very strongly that transitional justice is and should not be a sort of poor cousin of real justice. And I think the law on victims is probably a better example, because if I understand correctly, and I'm not following that closely, so I don't know, but if I understand correctly, it's a good participatory process, and it may be universal in its coverage of serious victims of all sorts. But even if that is the perfect reparations vehicle, reparations is one of the obligations that states have. It's not the only one. States cannot offer money to victims and say, but don't ask us for the truth, or don't ask us for justice, or don't ask us to reform our institutions. And that is my main caveat. That doesn't mean that we should discourage a good law on reparations, on the contrary, but just keep in mind, you've met only 25% of the obligations. Thank you. 2 more? Okay.
I'm Chris Einoff, and I teach at DePaul University's School of Public Service. And it's a management school, so I'm surrounded by people who believe that all programs should have logic models with cause and effect and measurable outcomes that you can measure statistically, right? So I'm curious, in your work, how do you know whether what you're doing is succeeding or not? And when it doesn't seem to be succeeding, how do you change your approach to do different things?
Well, I really don't know. And because we operate on, really limited budgets, we don't even have the resources to do serious, impact assessment. If we were an NGO, you would be sure that all the foundations would be on top of us saying, well, show us, what did you succeed in doing? And we just don't know, and there is no way that that we can do it. But I do believe that it's important, and it's important to do a serious assessment. But I hope it's a serious assessment for the purposes of improving on what we do, not for the purpose of saying, see, it doesn't work, so let's just shut it down. And the risk, especially at the Human Rights Council, is the latter. And so, we're kind of stuck. We all think that we should be improving, and for that, we should have a serious assessment first. And yet, we don't want to open the door to, to backtracking on even whatever we may be achieving, because we're always under scrutiny, we're always under pressure, and that could be a serious excuse for restricting us even further. Thank you.
Hello, Mr. Méndez. I'm Rajesh, and I'm a first year in the college. I just want to ask you whether you will consider the mass incarceration of minorities in countries around the world as a violation of human rights.
Well, yeah, again, there are other special rapporteurs and working groups that deal with this issue, and even treaty bodies like the Commission on Elimination of Racial Discrimination, the Committee on Elimination of Discrimination Against Women. There's a special rapporteur on indigenous peoples. The coverage is not perfect, because the Human Rights Council throws another special rapporteur every so often, and they don't even bother to think, well, that part of that mandate is already covered by somebody else. So it's kind of left up to us to decide, how we cooperate with each other. But the good thing is that we do cooperate with each other. In the case of torture, we often have to analyze cases and practices in which the person is tortured or is more prone to being tortured because he or she belongs to a racial, religious, or national origin minority. And there, we put even more of a spotlight on the problem and insist that governments have to be especially careful to make sure that the law applies to everybody the same way, and that in all cases it respects human rights. In that case, cases against the Roma minority in Eastern Europe have caused the European Court of Human Rights to issue some very good judgments. And I'm not talking only about discrimination in housing or discrimination in schooling, but also discrimination on protecting them from crime and treating them if they're suspects of crime. I would also highlight the case of the Inter-American Court on Human Rights on women victims of murder in Ciudad Juarez, Mexico, where the court unmistakably said this policy of not investigating these crimes is a pattern of discrimination for reasons of gender. I don't know if that's what your question was about, but that's what I wanted to say.
Thank you.
Thank you.